Friends, when I joined as chairman CCI in February 2009, some friends congratulated me, telling me that congrats, you've got a new assignment. By the way, what do you do? They didn't know what the Competition Commission was. And some of my friends from industry like you, they told me that we had enough mothers-in-law earlier. We had the CBI, we had the C&AG, we had various other bodies. We have another mother-in-law added to the list. What is the CCI? I had to tell them that this mother-in-law is a very affectionate mother-in-law which tries to help the daughter-in-law, and it would be helpful to you in a number of ways. And I try to explain that first of all, as the preamble says, the idea is to promote economic development and also to protect the interest of consumers. And in the present era, everybody is a consumer. All of you from industry know that you buy raw material, you buy services, you are a consumer, and you give your end product to somebody, then he is a consumer. So in the value chain, everybody is a consumer. So if the efficiency of the value chain improves, the consumers benefit by virtue of lower prices, by improved products, by technological innovations, then we have an economy which is dynamically improving. So there are static and dynamic efficiencies built in the system by virtue of competition. And it has been proved globally. Economic matrices, economic theories clearly bring out that competition benefits in a number of ways. And it has been benefiting every economy, every industry, and every country, which can be discussed and seen later. But coming to the present theme, which is the digital economy, how can competition law function, improve, help the players in the digital economy? Let us talk about this digital economy for a while. Digital economy, which is also known as the new economy, and it has shown during the pandemic how it has helped us. It has helped in pulling through this abnormal state of affairs in terms of the daily lives, in terms of everything. And not only the pandemic era, in fact, the whole world and the economy has been changing so fast. If we look at how the economy has been developing, economy has been developing in a disruptive way also at times, disruptive technologies. And I'll give you just a few examples. I know that we are short of time. In 1998, Kodak had 1.7 lakh employees, and they had 85% of the world's entire photo paper business. Whenever we used to travel, you would remember, I remember that from the duty-free shops, we used to buy those reels for our cameras. Now, within a couple of years, the whole thing became history. With the advent of digital photography, the entire business of Kodak, it was finished. I remember when I went to Los Angeles, the Kodak theater was the one where the Hollywood used to have their various annual functions. But now Kodak, nobody knows. Same thing happens in a number of ways. The artificial intelligence, it changed the way things happen. In fact, the IBM Watson, it has come up with models that very soon the legal fraternity, the doctors and everyone, probably they would also become redundant. And it would not be far away when companies like Tesla and Apple, they would make the transport sector completely different, the automobile industry, the self-driven cars and so on and so forth. The technology is changing very fast, and that is largely because of digital economy. Digital economy is making the earlier models and earlier industries obsolete. In a situation like this, it is necessary that even the competition law and the other regulations also keep a track in order to regulate the economy in a manner that this would improve the economic outcomes, and that is what is going to happen. If we look at the state of economy which came up during the pandemic era and how the digital economy helped us through, just for a couple of minutes. In terms of e-commerce, you would have seen that the delivery of goods and services at doorsteps was a big help. Otherwise, the pandemic wanted all of us to remain indoors and maintain social distancing. E-commerce helped in a big way. Teleconsult helped in a big way. Delivery of services helped in a big way when we could get, thanks to the various firms in this field, getting our barbers and our beauticians and our services, plumbers and everybody at our doorsteps. Similarly, in the field of entertainment, we could have, then in the field of delivery of food, Zomato and so on. So all these applications came on the digital platform, and it was obvious that during this 1 year that it was the digital economy which saw us through. And during this process, the invention, or whatever you may like to call it, the vaccines also was a great marvel. Normally, we used to be told that any vaccine would be developed in 4 to 5 years. Now, we had a vaccine which was developed in less than a year, which was another technological marvel. Bill Gates, in his celebrated book, wrote in 90s, Business at the Speed of Thought. So he predicted at that time that in future, business would have to be conducted in a manner and only those companies would succeed who are able to do their business at a speed of thought, futuristic thinking all the time. Now, our regulations, which have been designed on the basis of earlier models, obviously cannot keep pace with the advent of technology, and therefore the government and the CCI, they also took measures to upgrade their regulations, and therefore, as Dr. Sanjay Pandey said, the Competition Law Review Committee, it was set up under the chairmanship of the former Secretary Corporate Affairs in Jyoti Srinivasan, and all others were members, the chairman CCI, a number of others, even I was there too. They came up with their recommendations, and a new legislation is under draft, not legislation, amendment in the competition law, which would probably come in before the parliament, and there could be a number of new changes which would pertain to the regulation in terms of businesses of data. Data has become extremely important. Data, in fact, as they always say, data is the new oil. But it has a number of positive factors. It has a number of limitations. It is necessary that Competition Commission, they also look at it. Now, I'll just briefly mention about a few things relating to the new age economy. The Competition Commission conducted a few studies, as it was just mentioned by Mr. Sanjay Pandey. The one study which came out in January last year was on e-commerce, and Amazon and Flipkart. They were the subject matter of a few litigations thereafter, because soon after this study came about, there were a number of factors which pertain to the price level, and also in terms of whether you have specific or special relationship and so on. So there was a case which was filed in CCI, and that case is still going on. I am not trying to say that those cases were right or wrong, but CCI was faced with a number of such cases in e-commerce sector. There were cases in the transport sector against Ola and Uber. There were cases in the pharma sector, and so on and so forth. In those cases, it was brought out that the earlier rules which pertain to Section 3 anti-competitive agreements, horizontal or vertical, or Section 4 abuse of dominance, and Section 5 and 6 which pertain to combinations, probably they need to have a fresh look at. For example, in the case of combinations, Section 5 and 6, it was noticed that some of the major players, they sometimes bought over some of the small and emerging players in order to eliminate competition, which was also known as killer acquisitions. And some of the very big, the major companies, the FANG companies as they call it, Facebook, Apple, Google and so on, they have also been doing it in the past. So whether in those cases, the earlier parameters where the Competition Commission only looked at the size of the assets of the acquiring companies, they would be the relevant part, or they should look at something different. Just to illustrate, when Facebook acquired WhatsApp in 2012, 2014, the value of WhatsApp was not even $1 billion, but they acquired it for $19 billion. Imagine Facebook buying WhatsApp at $19 billion when the value at that time was much less than $1 billion, because it had potential of large volumes of data. And WhatsApp has now almost 54 crore users in India. And imagine the enormous data it could have. And now there are talks of integrating that data in the Facebook, with which there would be multiplication of data. Now, in India, it was not even applied for approval, this acquisition. Why? Because the size of that, the assets did not warrant that it would be sought for the approval in Indian competition law. So therefore, there is a talk that there should be, the definition should be changed, and the size of the deal, if the size of deal was supposed to be the criterion, then $19 billion size would have made it eligible for being reviewed, and then the Competition Commission could look at the possible implications of that. But having said this, I'm not suggesting that this deal should be blocked in any manner, should have been blocked in any manner. But the point I'm trying to make is that in the change scenario, when data is important, then you have to see whether the earlier rules, earlier gates were relevant, which were relevant earlier. Are they relevant still today, or we need to have a fresh look at it? Again, in Section 3, anti-competitive agreements, whether those kind of agreements would be relevant today. Section 4, abuse of dominance. Now, in a situation like this, whether you would call them dominant or not, again, something which would you would have to look at it, because the relevant product market and the relevant geographic market, the definitions would need to be changed. Would need to be changed because we have a cross-sectoral, at times cross-country territory, which could be relevant. In any case, a smaller set of things, a smaller geographic location may not be exactly relevant in a situation like this. So in the change scenario, in a digital economy, when everything is dependent on the use of digitalization, digital economy, it is important that we look at the implications or impact on the market, the way market is functioning in a situation when Section 3, Section 4, Section 5 and 6, the spirit of those sections would be relevant today. Coming finally to MSME sector, where the PhD is generally known to be the voice of the MSME sector. Let me tell you that the Competition Commission globally is considered to be a great friend of the MSME sector because they are generally attuned to genetically protect the interest of MSME sector from being exploited against by the larger sectors. So the entire philosophy of the Competition Commission is designed according to those principles. I may also tell you that the Competition Commission at times, it can be beneficial to the MSME sector or generally to the industry in a number of other ways. For example, if there are global cartels and those global cartels have resulted in increase of prices which have adversely affected the MSME sector or the industry in general. And globally, let's say in London somewhere, that cartel has been subjected to some penalties, fines have been imposed. Now those fines, not only the victims of those cartels in those countries can claim for compensation. In Indian competition law also there is a provision that victims who have been injured by these practices can claim compensation, and they can claim compensation in those territories also by virtue of the agreement which we have and the section 32 of the Indian competition law, which allows the Indian Competition Commission to look at the harm in such cases. So I wouldn't like to go into the nitty-gritty of many of these things. All that I'm trying to say, kindly don't look at the competition law in India as another barrier, another mother-in-law, which would be there to create problems and hurdles in your way. It can be useful, it can be beneficial, and the attitude of the Competition Commission these days, I can tell you, although Dr. Sanjay Pandey is here, he would be able to allude it to much better this thing, that they are very helpful, they are very proactive, and they have not been taking any unduly adverse view in such matters. Having said this, my last and final word would be that the best practice would be adherence to the competition law and the compliance. So for the compliance, these studies which have come out, the last one is on pharma. And I've gone through that study in detail, number of good features. One can suggest to the industry, the pharma associations, how they can make themselves adherent or compliant to the principles of competition law without spending anything or changing their rules and regulations in a substantial way, or similarly earlier in the e-commerce sector and so on. So altogether, the best way to proceed today would be to get compliance study, compliance audit conducted in your industries and in your associations, trade associations in particular, I would say. In fact, I wrote a big paper along with a friend of mine, Professor Rahul Singh of NLU, and that paper was published globally in various journals. So we specifically alluded to it, how trade associations need to conduct their businesses globally, because now it's a global competition or antitrust law, in order to stay on the right side of their competition or antitrust laws. As it was just mentioned, there are now nearly every country has got a competition law, over 130. So it would be useful to abide and to remain attuned in accordance with the competition law. Thank you very much. I am really grateful for this opportunity, Mr. Sehgal, and I am one of your members on the managing committee. I would always be available to you, and it would be a pleasure for me to be of any help to any of your members, pro bono, to be of any help in adhering to the competition law. Thank you very much.